Further speakers? The Honourable Tania Mihailuk.
Thank you, Mr Assistant President. I speak to the Anti-Discrimination Amendment Religious Vilification Bill of 2023, which seeks to amend the Act to outlaw vilification on the grounds of religious belief or activity or lack thereof. And can I just state from the outset that One Nation will not oppose this bill. It comes at a time when there is a clear and persistent agenda that is increasingly hostile to religious belief. And as I've previously said both in this House and in the other place, the issue of vilification of people of faith generally and the protections afforded against it is of vital importance to our social fabric. There are provisions against vilification in the Act on the grounds of various attributes, including race, transgender status, homosexuality and HIV/AIDS status. But despite ethno-religion being included in the definition of race, there is no protection against vilification on the grounds of religion, and I welcome this move to remedy this anomaly. But I do question why is Vince and Labor proceeding with this now? Is this to pave the way to support the left's agenda of eroding our social norms and ridiculing our moral standards? Why not wait for the ADA review that they have commissioned to be completed, that's currently before the Law Reform Commission? Chris Minns announced this change at a forum in Parramatta on the 27th of February as an election commitment. It was an attempt to placate faith communities on the back of his previous recent announcement to the LGBT communities regarding banning conversion practicing. It was a case of walking both sides of the street and wooing the much-needed support that he needed of the left-wing crossbench in anticipation of a minority government. This bill is more of a fig leaf to cover this government's naked indifference to people of faith than an olive branch to religious communities. It serves as a distraction from what people of faith genuinely need, what they have really been asking for but continue to be let down. This is an offer of a few crumbs to appease religious groups and people, which rather than actively protecting religious people would mean they would have to prosecute a case before the Anti-Discrimination Board if they are subjected to vilification. It means they have to make an application, bear the onus of proof. Why not just make sure that religious belief and activity is on par with other protected attributes in the ADA? But we need to address that because it is the elephant in the room. The bill does nothing to address the fact that the Act does not include religion as an attribute to be protected from discrimination. Why is this government choosing to highlight vilification now? Surely because it's the easiest thing to tick off so they can say they've done something for people of faith. The glaring omission in the Act, as it currently stands, is not the lack of protection from religious vilification, but fundamentally that religion is still not included as an attribute to be protected from discrimination. The Act provides broad protections from discrimination on all sorts of bases, including race, sex, disability, age, marital or domestic status, homosexuality, transgender status and carer responsibilities. But it is still not unlawful to discriminate on the basis of religion in New South Wales. And I anticipate that the government will tell us that we must wait for this comprehensive review of the Act before any such changes can be made, that religious people just need to wait a little bit longer so they can make a proper job of it. And the Leader of the Government, in response to my question on Tuesday, did say that the government has referred the Act to the Law Reform Commission so that they can systemically work through the discrimination protections in this state. More stalling, more delay, more deflection. Something is needed now to address this injustice. And it's really simple. We need to amend the Act to give religious belief the same protections from discrimination that exists for the other attributes that broadly fall into the same category of universally recognised basic rights. It's been, Mr Deputy President, it's been 5 years since the Ruddock report, which included recommendation 16, that New South Wales amend its Anti-Discrimination Act to render it unlawful to discriminate on the basis of a person's religious belief or activity. Despite being a report commissioned by the federal government, it singled out New South Wales and South Australia for being the only states not to have these protections. And it's been 2 years since the report of the Joint Select Committee on the Anti-Discrimination Amendment, Religious Freedoms and Equality Bill of 2020 was finalised, which took 4 days of public hearings, received 192 submissions and made concrete recommendations to the government, to the then government, the coalition government, to amend the Act to protect religious people from discrimination without delay. And importantly, recommendation 4 of that report envisaged a broad-based review of the Act, which might consider introducing protections from religious vilification. But as to the discrimination, it was quite explicit. No further review should delay implementing protections for religious discrimination here and now. Mr Deputy President, such a reform was seen as so urgently needed then as it is now because of the alarming change in attitudes towards religion and tolerance that's happening in our society. The inquiry conducted a survey to gauge public support for outlawing discrimination on religious grounds. Of the 19,403 responses to the survey, 68.1% were supportive, and a 2019 survey of 55,000 Australians conducted by the ABC, not only did 70% of religious people say they thought religious discrimination was occurring, but 68% of respondents of no religion agreed. During the inquiry of the Joint Select Committee in 2020, we heard of many such occurrences of this discrimination, concerns about the need to protect people of faith from religious discrimination, as were felt deeply across all faiths. As the submissions from the Catholic Bishops of New South Wales, the Australasian Middle East Christian Apostolic Church attests, it states, and I quote, "Until very recently, the importance of the free exercise of religion to Australia's social fabric has been largely uncontroversial. However, there's been a recent shift in the openness of some elements of Australian society to religion and religious believers. For all its talk of tolerance, there are powerful influences in our culture less and less tolerant of religion. There is now more hard-edged determination to minimise the role of faith in every life and exclude it altogether from the public square." Further exploring the growing concern of Islamophobia in New South Wales, in its submission to the Joint Select Committee, the Lebanese Muslim Association welcomed laws against vilification, but also called on the stark lack of protection from discrimination. And I quote, "Since 2014, New South Wales has consistently recorded more Islamophobic incidences than any other state or territory by some significant margin. The LMA is acutely aware of the painful impacts of anti-religious sentiment and incidences, particularly as it relates to Islamophobia in New South Wales. The aftershock and effects of a single Islamophobic incident extends beyond the person targeted and quickly spreads across the Islamic community. As there are no laws in New South Wales to protect against discrimination on the ground of religion, Muslims who suffer from discrimination are left without legal recourse." It's also important to note, Mr Deputy President, that it's not just religious groups that raise their concerns. The Institute for Civil Society stated in its submission, and I quote, "Australians who regularly practice their religion are in a minority. Those who follow traditional religious practices on matters like sexual ethics, marriage, sanctity of human life, prayer and fasting or religious dress are an unpopular minority in some quarters. Like other minorities, they experience discrimination, but they don't have the same legal protection as other minorities in New South Wales." The Institute also submitted some serious and troubling examples of those discriminated against in the course of practising their faith, and went on to say, and I quote, "This lack of protection for people from discrimination in New South Wales on the basis of their religious belief or activity based on religious belief needs to be remedied now." There were many examples of religious discrimination given to the inquiry, such as people being forced to step down from boards of religious organisations simply because their main employer found that religion to be incompatible with their values. And particularly in this digital age, we saw repercussions to employees, ordinary people, for expressing religious belief on social media, despite it having nothing to do with the company that they work for. There's a clear agenda emerging of a rigid, enforced conformity to the company line on things, totally unrelated to the work carried out by that company and irrespective of its employees' consciences. Even when there is no direct discrimination, many have the sense that their career progression will be limited unless they keep their beliefs and religious observances hidden away. And I want to make a comment, if I may, at this point in relation to the former Attorney-General Mark Speakman, who now, of course, is the opposition leader. He told us in his capacity as then Attorney-General that his government at the time agreed with the recommendations of the Joint Select Committee, but that we should wait for the federal government to implement its own legislation in response to the Ruddock report. And the federal government had already been procrastinating, as we know, for many, many years, and the eventual failure of the Morrison government to pass the legislation is now history. There was never such need to wait for the federal legislation. We know this. Recommendation 16 of the Ruddock report was entirely independent of any federal legislation, and there was absolutely no reason for Mark Speakman or for the coalition government then to wait. But wait they did. And as we saw, bringing New South Wales anti-discrimination laws are still not in line with the majority of other states, because the coalition government had its opportunity in the last 2 years and they failed to make a difference. The line that we will no doubt hear from the Labor government, of course, will be now that they have to wait for this broad-based review of the Act, despite the fact that recommendation 4 of the Joint Select Committee called for this reform immediately, notwithstanding any further reviews. So, Mr Deputy President, how long must people of faith wait in New South Wales? We've had the Ruddock review for 5 years, we've had the Joint Select Committee's review from 2 years ago, which said that the reform needed to be done immediately. But more so, a comprehensive review of the Anti-Discrimination Act was actually undertaken 20 years ago by the New South Wales Law Reform Commission then, and it gave the people of New South Wales a 587-page report back in 1999. And what did it include? Well, recommendation 38 stated that religion be included as a protected ground of discrimination. And that report observed that, and I quote, "It is perhaps ironic, given the importance of it attached both in our Constitution and in international instruments to which Australia is a party, to protection from religious persecution, that discrimination on the grounds of religious belief is not covered by the ADA. The anomaly is accentuated by the prohibitions which exist in other Australian jurisdictions." That's page 201, if anybody wants to read it. If we still can't implement this reform that was called for back in a comprehensive review in 1999, why should religious people have any confidence that after waiting for yet another lengthy review process, that the eventual recommended reform will even be implemented? If the government wants to commence the review of the Act, the Labor government that is, by all means it should start that process, but there's absolutely no reason why this change cannot be made now, so that any further review be made from the starting point of religious faith having the same protections as the other attributes in the Act. Mr Deputy President, I'll now turn to the detail of the bill. The amendment to the Act is sought through the insertion of a new part, 4BA, which contains sections 49ZD and 49ZE. 49ZE would outlaw public acts that incite hatred towards, serious contempt for, or severe ridicule of a person or group of persons on the ground that they have or do not have a religious belief or affiliation, or engage or do not engage in religious activity. 49ZD defines public act consistently with other vilification protections in the Act. Consistent with other provisions in the Act, 49ZE2 provides some exceptions, which includes a public act done reasonably and in good faith for religious instruction purposes. And I note, though, Mr Deputy President, the concern that despite this exception, this bill could have unintended consequences of stifling free expression of religious belief. While some complaints to the Anti-Discrimination Board may go on to be dismissed under this exception, this does nothing to mitigate that for many the process itself is punishment enough. These provisions should be a shield from vicious behaviour, but we have seen other vilification provisions used as a sword by vexatious litigants. There's no protection from complaints being made on frivolous grounds, to which ordinary people are left to pay their own costs for the action they are forced to engage with and defend. The Legal Affairs Committee's inquiry into the Anti-Discrimination Amendment Complaint Handling Bill in 2020 raised similar concerns and recommended reforms including allowing the President to refuse to hear a complaint if it falls within exception to unlawful vilification. And the report noted, and I quote, "The committee is concerned that some individuals have the ability to use the complaints process inappropriately in situations where they may not have been personally impacted. We are concerned about the unfair pressure this places on respondents and how this goes against the very principles of fairness anti-discrimination legislation aims to achieve. The Attorney-General should make it clear how the government intends to mitigate these concerns, particularly in relation to the reform proposed by this bill. The bill does take the unprecedented step of protecting an attribute from vilification without a corresponding protection from discrimination, and that is a very important distinction for this House to appreciate. It also seeks to give the same protections against vilifications on the ground of lack of religious belief. The government needs to provide assurance that this bill will not lead to religious people being unjustly subjected to frivolous actions or perversely limiting religious freedom by causing genuine people of faith to self-censor for fear of activist lawfare. So, Deputy President, at the 2021 census, more than 54% of Australians responded as having a religious belief. In New South Wales, the most religious state, the figure was well over 60%. This is despite a high-profile campaign from a coalition of secular groups trying to induce people to mark no religion in the census. Those figures incorporate a diverse range of religious affiliations and beliefs, but what unifies those groups is a fair and reasonable expectation that they can observe and practice their religion without fear of being discriminated against as a person of faith, and that right is recognised internationally in the Universal Declaration of Human Rights, which former federal Labor leader Bert Evett helped draft. It's also in legislation in every state except New South Wales and South Australia. Religious protections in Victoria, Queensland, Western Australia, Tasmania and the Australian Capital Territory were introduced, funny enough, by Labor premiers, from Steve Bracks to Wayne Goss, while it was former Labor Prime Minister Gough Whitlam and Kevin Rudd who enshrined religious protections in Commonwealth law through the Racial Discrimination Act of 1975 and the Fair Work Act of 2009. In 1991, the then Prime Minister Bob Hawke said Australia's multicultural society works because all Australians are able to express and share their individual cultural heritage, to practice their religion, to speak their language. It was also Hawke who told the visiting Pope John Paul II in 1986, and I quote, "The government and people of Australia share your commitment to the cause of peace, religious freedom, development and human rights." Well, the record shows that Labor once, historically, was perhaps a party that cared about religion and faith and protecting people from discrimination, but no more. So I say to Chris Minns, why can't you follow the example of your Labor predecessors and move quickly to implement this vital reform? Labor was prepared to act in other states. Why isn't Chris Minns prepared to act now? One Nation, as I've indicated, will not oppose this bill in its current form, but we should not pretend that this small step is in any way adequate to give people of faith the protections they really need and deserve. And at the committee stage, as I've indicated, Mr Deputy President, earlier in my speech, I will call on the House to recognise this and to support my amendments.